Good morning, everybody.
Morning.
Welcome to the Cannabis Legal Group's 48th Cannabis Live. I'm Craig Aronoff.
I'm Nick Galendez.
Yeah, along with my colleague Nick. We are attorneys with the Cannabis Legal Group in Royal Oak, Michigan. Our firm specializes in all things related to the medical marijuana industry here in Michigan, including the MMFLA, or New Medical Marijuana Facilities Licensing Act. We'd appreciate it if you ask questions throughout the broadcast. Feel free to. We'll do our best to answer them during the show. If not, we'll get to you after the show. If you wish, you can see at the bottom of our screen here, there is a link to our website where we have a municipalities page that's still updated regularly. Again, if you're looking for a location, it's a great place and source to use to help find those locations that have opted in, those that are still considering it, and seeing what all those ordinances look like. You'd also find our prior shows at the YouTube link below as well. We have all 47 of our other shows posted there, and would love to continue to provide information for you. Cannabis Legal Group is located in Royal Oak, Michigan, as I said, and we're going to be talking today about a few different items, in particular deficiency notices. Pretty exciting topic. We're seeing more and more of them as the Lara's work is beginning to dig in deeper and deeper, and so I wanted to show you what a letter looks like from March and kind of walk through some things that we've learned along the way. We're also going to talk about a recent bill that was passed by our Michigan Senate that is at least making it through the process, proposing to ban marijuana-infused spirits, right, wine, liquor, beer. And we can talk about what impact that has, if any. It's actually kind of a non-starter given the way the law is set up, but I suppose we'll just acknowledge what Mr. Jones is trying to do from the Senate. To that end, feel free to ask questions throughout today. Nick and I are happy to answer them. And why don't we dive into deficiency notices? So
I was going to say, let's talk about beer first. I think all our listeners want to hear about beer on 10 a.m. on a Friday morning. So,
sure.
So basically, Senate Bill 969 was recently passed by the Senate. It still needs to go to the House for a vote, and then the governor would need to sign it. But basically what it does is it kind of plays around with the Liquor Control Code of Michigan. It basically says that you can't offer for use, possess, or sell marijuana-infused beer, wine, or spirits, which would be liquor, kind of mixed drinks. And if you do that, you would violate the Liquor Control Code and be guilty of a misdemeanor. What are your thoughts about that?
Well, it's just what's a little bit absurd is that the 2008 Marijuana Act doesn't let you have basically alcohol and marijuana together. So we're already in a position where you can't, sell liquor at a place where you're actually selling marijuana. And the way the marijuana law works for the Facilities Licensing Act, again, you can only sell licensed products, which won't include alcohol or other spirits. So I'm not sure where Senator Jones thinks that these products would be available in the marketplace. I think the challenge that I don't like about it, if any, is, of course, the idea that you can't possess it. If you're a caregiver at home and you're rightfully possessing, or a patient, and you're rightfully possessing your medicine, and you choose to take a low, THC version of it, maybe a non-psychoactive version, and get the benefits of that cannabis oil and want to put it in wine, which is available in California, you can't do that here in Michigan. Similarly, you can't put it in beer the way it's allowed in Ontario. And so I don't like that other markets have opportunities to create and innovate where Michigan won't be allowed to. I also don't like that for personal use, where patients who are allowed to have it are going to be limited on the type of medicine they wish to utilize and how to supplement that.
Yeah, and I also think practically the Facility Licensing Act and the potential adult use initiative aren't going to really be touched by this, because from my understanding, while you could infuse marijuana products either for a medical license or for an adult use one, if you do get up and running, if that liquid happens to have an alcohol content that would qualify as a beer, wine, or spirit, then you would need a SDM or an SDD, basically a liquor license, to do so. And it'd be very rare, if impossible, for both of those licenses to coexist anyway. So I don't know really what they're trying to get at with this bill, other than preempting something that might not even be an issue or could possibly be an issue under either one of the laws. So that's just a little bit confusing as well. But definitely share your concern about that.
There are some exceptions. Bona fide scientific research, college, universities conducting bona fide research, biotechnical companies. So there's going to be some opportunities to allow innovation to happen in the tech and the research sector. But unfortunately, for these licensees that are maybe carrying a process license where they are allowed to make concentrates and basically be no limit on the extent of their concentrate catalog. They can have all types of different products that they infuse, except for now anything that relates to alcohol, beer, or wine. And so that's before we even get started to even try to find some other versions, and again allow that innovation and technology to take over. Wendy, you were asking questions about the recent CBD crackdown. Please, I'd encourage you to watch episode 47 where Nick and Travis, our other colleague, discuss that at length. But the short version really is that until it's licensed in the state of Michigan, it shouldn't be on those shelves for the temporary operating facilities. So we got to be careful that those aren't operating as MMFLA facilities yet. Until they're fully licensed, then there can't be a product that's licensed for them to sell yet. And so we just want to be a little cautious that what we're seeing today from these storefronts is not exactly what we're going to see down the line, because they're still supposed to operate as an MMMA caregiver center. And so we just want to be careful with that. That all being said, I think that, Michigan is going to evolve. Hopefully some House representatives and or the governor don't agree to that and we don't have this bill signed, but it is something that the discussion should take on, and we'll see how it develops over time. So turning our attention to the deficiency letters that really at the onset, and the joke here is of course that if you get one, you can't drown your sorrows in any kind of marijuana infused alcohol. But that is something that we'll have to address later on. Brad, you were asking about tobacco products, and I think that it's not an unreasonable expectation that another licensed limited product like tobacco is going to have some limitations. We haven't seen that come from Lara that I'm aware of yet, but the idea that they're going to prevent tobacco wrapped blunts and stuff like that, I don't like the idea of it, but it's still something to consider that might not be available in the future. Because that retailer has to have a license to sell that tobacco as well, or the opportunity and authorized to do so. So let's look at what a deficiency letter looks like. What I've got on the screen is a redacted version. Our office has received a number of different clients that came to us after submitting files on their own behalf, and we've seen some deficiencies that they've asked us to cure. And this is an example of one. And so what I want to do is first and foremost, as you'll see, it comes from Lara. It's pretty clear what it is. If we scroll down on it a little bit, you'll see that what they do is they really break it down by individual and then also supplemental apps. They'll tell you the disclosure. They'll go through the list of concerns they have in that disclosure. And I think a very important point to make at the onset about deficiencies is when you receive your first one, if you do, don't assume Lara has done anything with respect to the balance of your application yet. I think it's a very fair statement to say that Lara is doing it incrementally. Mm-hmm. And so this is an instance where this particular group had actually filed their application, received a deficiency notice, cured that deficiency notice, and then received this notice that had a whole bunch of deficiencies that were readily available from the onset. Mm-hmm. So why don't we get into that a little bit?
Yeah, and I mean, it's going to be a discussion process, and objectively, if you put yourself in the place of the analysts and inspectors that are looking at this, they'll be getting hundreds or thousands of pages of documents and disclosures. What they do is I think they do an initial intake, and they elaborated on this a little bit in the earlier advisory bulletin on the application process they released earlier this month. But they'll do their initial intake and look for any obvious omissions or any obvious kind of things that they need you to follow up on. And I think that's where the primary information in these first deficiencies is.
Yeah.
And they'll give you an opportunity to correct those, but then they'll continue to process it and dive a little deeper. And so it'll be a back and forth kind of conversation with Lara.
It certainly is, and it's almost like once they figure out something big enough, worthwhile to tell you about, they're going to hit the pause button on their end, submit that back to you, and then look to receive it. But notwithstanding, the reality is that what we're really seeing is it's an evolution. I think that there's even an opportunity that after fingerprinting, for instance, as we read through the advisory bulletin from last week, you could be fingerprinted, and then when they go back through, they're looking to match up what you said you were providing, say, through your criminal history, and of course, what pops up from your fingerprint search. Mm-hmm. And so, again, there's no point in time until that report is given to the board where these deficiencies might not be made readily available. And what's important about it is how do we cure it? Really, what do we do when we're looking at it? And our approach has been to really kind of go back through and do a full audit of the file. Not only look at the questions that, are being addressed in the specific deficiency, of course, which need to be at the top of the list, but the second part of that is really, also what might they ask that we haven't addressed yet, especially for clients that we didn't do their initial application. So if that's the case and you bring us a deficiency, it is something we will work on. And what we'll try to do is determine what the project would be and really kind of dig into that app and see, because we're finding areas where, maybe a teaching license or something wasn't disclosed before. Mm-hmm. It's information they want to see. Yeah.
And that's why it's important to, from on our end for our clients, what we're doing is taking a full accounting of their application initially. And what we'll do then is, if and when we were to get a deficiency for those applications we submitted, we'll then compare the deficiencies to what we actually submitted. And so for all of those of you who are preparing your applications on your own or even from another source, if you were to come to us or any other attorneys or consultants with deficiencies wanting help, it's really important to keep a record of exactly everything you submitted to LARA, in what kind of form that you submitted it to them, so that, if we are responding to deficiencies, that really helps out instead of trying to put the puzzle together upside down and having a lot of questions with what was sent to them, what are they saying is deficient, was that actually sent to them? So.
Yeah, no, organization is key. Making sure that we know exactly what they have, when they have it. It's true, too, that we've been asked to review a deficiency that when we looked at the application itself, there was information already responding, on the initial application to the deficiency itself. In other words, Laura missed it. And so that'll happen along the way where the deficiency is asking for something they received already. And so, again, they're doing their best. This isn't a criticism of Laura in any stretch of the imagination. What it is it's a realization of the depth of work they're doing and the need to have an organized, solid application submitted and be ready and willing to take on those, requests for deficiencies and then take it from there. I think that, that is another point to be made. Laura will answer questions. And so, at times we'll ask them a number of different questions, be it big or small. They answer the phone, they respond to emails. So if you're not sure of something, if you get a deficiency notice and you're just not clear what they want, follow up with them, ask them the question. We'll work with you on that.
Yeah, and a lot of these questions, too, I'm sure that we've been asking and everyone else has been asking is very fact-specific. So they might have generally answered a question related to that, but based on a particular applicant or entity or structure and specific situation or business or bank account, it might be unique to them. And so, I've got to give them a little bit of time to get all of their answers, fully thought out and come up with one consistent direction to go from. We're all kind of, learning as we go along, and the department is still formulating all of its rules, and having those more concrete rules coming in December, I'm sure will help. So it's definitely a learning process for all those involved in the industry so far.
Yeah, no, there's no doubt. I mean, certainly, and I think we've addressed it in the past, it just, the learning curve is in process. And so, what might have taken them 10 days, a few months ago to review could take them 7 today, and maybe in the future it'll take them 5. And so we got to give them time to ramp up their skill sets. But what's also happening, and I think this is an important point on the financial disclosures, is the depth at which they're really digging in. So there were some questions that a number of different applicants have asked in terms of, I have, I'm a real estate developer and I have, 50 LLCs relating to a number of different rental properties and other sources of business interests that I have nothing to do with cannabis, do they need all those bank statements? Do they need all those deeds? Do they need all the information, tax returns related to them? And the answer is generally yes. As frustrating as this is. But, as maybe a mitigating factor, something that we can maybe do to see exactly whether or not they need it for this particular client and whatnot, is provide a real comprehensive overview of what those accounts are. Right?
Yeah, because I think that, again, objectively looking at it from the department's position, they'll be getting disclosures of people they've never seen or met that are just named on different financial documents and tax returns. And, it's true you'll disclose all of them and what business interests you own and how much percent you own, and maybe your name will be listed on the bank account. But then that's all they really can see. And so that only provides some of a picture to them. The tax returns only provide a little bit more there. I think, going forward, knowing that they might want a comprehensive overview, your role in the company, what your source of income is, even the same thing on the bank accounts, what the purpose of it is. I think, again, just going along with our theme about applications and disclosures, being proactive and providing narratives, either to explain to Lara why these might not be things that they need to look at, or just to generally to provide them with that kind of context so that it can help them vet you and go through the process a little more smoothly, so they don't have to ask those follow-up questions 2 or 3 or 4 times in the future.
Oh, certainly. And their time is really dedicated to looking at every page within each of these tax returns, each of these bank statements. And so, if you have any kind of larger deposits that you made, any kind of larger withdrawals, any kind of transactional history that isn't within the normal curve of what they'd expect to see in your account. And it might be a one-time transaction. A great example of this is, somebody we worked with that had a sale of real estate that resulted in a large deposit into their account that wasn't normal. It was, literally an $800,000 transaction that came onto their deposited account. And what we provided with that account is the deed and the HUD and the transaction history that showed this money related to this sale. And therefore, there's not a question that they'll come across in that person's history as to where that $800,000 came from. But, over the course of 3 years, there might be a lot of, transactions that an account has. And so if there are things that are worthy of pointing out because they're not clear on its face, this is the time to provide it. And even if they're sitting and you're waiting in the queue and you don't know yet that you'll be reviewed, go back through your application, rethink some of the questions you might be asked, and supplement. You're always able to provide additional information, right? And so we can do it by email, we can mail it in. The key is be complete. So if you go back through your records and you see, there's that odd sale that occurred, I made a $30,000 consultation fee or whatever might come up, I had to pay a medical expense that was significant.
Yeah, and it's even, the more smaller things, like if, on disclosure 1, you have to list your prior names or prior addresses. And even if you show that you lived somewhere for the past 3 years and you've lived at your residence for longer than that, even putting down not applicable in those little boxes can make the difference. Another example, if you opened up a bank account last year, they ask for 3 years of that account. While they can maybe look at the first statement and show, this was the initial deposit, providing that extra narrative can go a long way, because maybe the analyst who has to look at thousands of these might not notice that, and would help them to do their job if you just made it explicit that that's why you didn't provide any more, just because there weren't any. So I think just learning the intricacies and nuances of how the state's looking at it, how applicants are preparing it versus how the state wants to see it, and the types of deficiencies that do come out to different applicants is very helpful going along.
Yeah, no doubt. And, Paul, you were mentioning a 501(c) and whatnot. And the complexity of those as being a charitable organization is significant, because you got to be accountable for all the monies raised and how much of a percent went to the people running it versus those that were actually donated to the charity and everything else. That is true. I mean, again, every dollar these people are bringing, every dollar an applicant is bringing into this industry needs to be accounted for. And, the goal of Lara from the onset, what we saw from the initial, from the time that the MMFLA was even in discussion at the legislative level before it passed, when it was simply a public act, was always, how do we prevent dark money from coming into this industry? And so they're really looking at all those angles. But in the same vein, we got very, sophisticated people with a lot of different companies, a lot of different interests. And really, what does Lara need to see? It starts with everything, unless there's a way we can explain it in such a way that maybe they don't, and we can take a chance that they might not, but the chance could result in a delay in your application because of this deficiency. So you got to wait out. Is it better to over-disclose versus choose what to disclose as far as whether or not that's fully something they needed to know about?
Mm. And also, I think that too, it's how you interpret what the disclosures and application and instruction booklet and the law and emergency rules, which is a lot of things kind of that are, somewhat on the same page, but do have various different wordings of the language in them. But it's what they're actually asking for. Just another example. Disclosure 6 asks if if you're currently subject to regulation by a public agency, and then it also asks if you've ever had a certificate or license not renewed. And that could be something where you were a teacher 20 years ago and decided not to renew it because you're changing careers. Based on your restrictive or liberal reading of the rule, you might want to disclose that, and Laura might want to look at that. And so those are all things that you can just anticipate either from a really restrictive or really liberal reading of it. And I'd say until there's any word or clarification, it's better to be safe and sorry and err on the conservative side and just disclose that. It can't hurt, if you have your certificate lying around with a number on there and providing that narrative, just in case later on they come back and say, we see you have certificates that were not renewed. Please explain why. And it can, shore the process up a little bit more and make it more streamlined if you do just give them that, up front.
Yeah, there's no question about it. And, that was a great example to talk about, a teacher or somebody who, no longer is actually teaching. Maybe they're onto other industry. Maybe they've, done whatever they can outside of that. That's true in every kind of regard. So, if you've been registered with a state and have had some kind of certificate of licensure of any kind or permit, that is something that's authorized by a licensing division. That is just, again, this goes to over-disclosure. I think it's fair to say, and this is the comment that I think a lot of people see, they're basically finding everything. I mean, they're really digging in deep. They're going through every layer of the onion on each individual applicant. And again, those questions that you're causing them to ask is going to hit the pause button and result in a deficiency versus anticipating the questions and answering for them. And I think that that's the approach that we'll continue to advocate. I think we kind of showed what the letter would look like. Again, for those that maybe joined a little bit later, it's a screenshot of one. As you'll see, again, they go through the different disclosures. They want to be very specific. The attestations are important, so we're seeing some comments coming back from Laura on attestations and what was actually necessary for the source of income. Again, simple things like putting NA into all the boxes that they're asking you questions. If the top box, say, of the government, are you, married to somebody or anyone in your family, work for the government? If you say no at the top, then that basically clears the rest of the document. In some other areas, just because you have a current name doesn't mean you didn't have an old name. So you got to say, I didn't have a prior name. And as silly as it may sound to us, NA is important to be put in there. Similarly, too, there could be people that have multiple names on, bank statements. Do we have to submit them twice? Referencing the account and having that account available. Let me scroll back. Okay. Oh. Yeah, and so, those are things that are important about it as well. So, in any event, let's go back to, just talking in general. I think, Wendy, you'd asked a question a little bit ago. Why don't we circle back to your question asking us about, last episode and, some lack of clarity that we have in the CBD and the MMMA. We have to remember that the MMMA authorized caregivers to take care of 5 patients. And, a lot of the product lines that are on some of the shelves at dispensaries today were not produced by caregivers. And I think that's the simplest answer as to why maybe they're not allowed to be on those shelves. Now, if there is a product that is produced by a caregiver and has been transacted properly under the MMMA, maybe those type of infused products could find their way onto shelves. But the idea that the DEA has actually ruled that, these are definitely marijuana Schedule I products puts this into the definition of Michigan's MMMA. Mm-hmm. And it's important that those, these providers answer that question and have the license necessary to sell them.
And I think too, as we transition to the MMFLA state operating licenses, I think all parties agree that all products that are going to patients need to be tested and fully safe. And I think right now those that are on the shelves, even with a proper label on them from a somewhat reputable source, hasn't gone through the testing that the state's going to want to require for all marijuana and marijuana-infused products. This is an agency interpretation based on the existing law as it is right now. I think that that's very helpful, and they're not looking to pull the rug out from anybody. They're just really trying to clarify exactly what they consider to be a marijuana product that needs to be sold by a licensed facility after testing and so on and so forth.
And let's remember, too, that they're also reacting to the federal, cases and some interpretation by the DEA and a case law where, unfortunately a court found that, hemp should remain within the Schedule I definition. And so that actually then, has this ripple effect through all these different markets where some type of CBD products are available in some markets and not available in others, because of the laws within those states as to how that is defined between a marijuana-infused product and a hemp-infused product. Unfortunately, in the state of Michigan, hemp is included in the definition of the cannabis sativa for our definition of marijuana. And so we follow that same DEA ruling, and until that's changed, maybe through the rec bill, we're going to be stuck with this limitation on where CBDs can be sold.
And I think, too, just kind of zooming out a little bit and talking about economy and industry, similar to the medical marijuana or marijuana-infused beer ban, when government places regulations on you, whether that's federal or local, it kind of restrains us compared to those like Canada, Colorado, California, even the entire international market for medical marijuana, certain adult use markets, hemp, CBD. All of those things kind of hamper innovation to a certain extent and will really kind of put us at a disadvantage once all of that is, in the future a little more allowed, and less in the gray area. And so those are all kind of policy decisions that may or may not be made at a different level of government that really impact the whole economy and people and kind of the way the world works.
Yeah, and the reality of what CBD is and its effect on people and so on. And so we're going to continue to see an evolution from the federal government. Yesterday, actually, there was some great news that came out of the Appropriations Committee where Representative Joyce actually took on what was, the Rohrabacher rider in the budget and has produced that in a committee that even got before Rohrabacher. And so, it looks like our protections will continue to prevent federal prosecution and use of DOJ dollars against state licensed entities. And that's a very important, protection that we'll all continue to have as Michigan's market comes online and continues to grow. And so, we had a lot of content in today's, conversation. Certainly, we appreciated all the comments and questions, and hopefully we addressed them. If there's anything that we didn't get to that you'd love us to take on, please let us know off-site. You can reach us at the Cannabis Legal Group, both on Facebook as well as cannabislegalgroup.com. Look for our shows on YouTube, and we'll look forward to seeing you next week with another topic here on the Michigan Marijuana Facilities Licensing Act or anything to do with marijuana in Michigan. So for Craig Aronoff,
Nicholas Galendez,
we'll see you next week. Have a great day, everybody.
Bye.